Again, welcome to Compensatory Education versus COVID Compensatory Services, tonight's webinar on February 9th, presented by Jackie Lembeck. Disclaimer, the ARC of Lehigh Northampton County Advocate Department does not employ lawyers nor provide legal advice. This training or any other provided by the ARC Advocacy Department does not constitute or imply the endorsement, recommendations, or favoring of the providing parties or any employees or contractors acting on its behalf. This webinar is being provided for an educational and informative purpose only. And now it is my pleasure to introduce our guest presenter, Jackie. She's an attorney at McAndrews Law in the Special Education Department. Jackie uses her past experiences presenting both parents and school districts to legal challenges and offers creative solutions to her clients' concerns. She represents clients in all stages of special education disputes, including IEP meetings, mediations, resolution meetings, and administrative due process hearings before the Office of Dispute Resolution. She graduated from Villanova and Emory University School of Law with honors. Thank you for your time, and the Zoom is yours, Jackie.
All right, well, thank you so much. I first really want to thank the ARC for having me here and putting this together. It's a wonderful platform that they've given you, and they're just wonderful people to work with. When I've presented in the past, it's always been a great dialogue and discussion. So I'm just very happy to be here. So I do have a PowerPoint for you, but right now I'll just kind of give you a little bit more of an introduction. As you've heard, I'm a lawyer, I practice law, I represent families and students with disabilities in special education law. That's my sole focus. And I have worked on both sides of this issue, also representing school districts in the past in my career. So I'm hoping to be able to bring you that kind of nuanced perspective of what are some of the challenges on each side, because frankly, special education was difficult to begin with, and no surprise, a global pandemic did not make any of this easier in terms of anyone, in terms of implementing and the problems that come across with that, and in terms, of course, of having children receive the free, appropriate public education that they're entitled to. Okay, so we're here to talk about a really, really fascinating topic right now, a very timely one: compensatory education versus COVID-19 compensatory services, which is abbreviated to CCS. So these are two different and distinct remedies. Unfortunately, people tend to use the same term or same abbreviations somewhat interchangeably, which can really muddle the conversation. So I'm hoping that what we'll do tonight is really break it down so that you'll understand, what each is, when it may be applicable. It seems like, we have a lot of interested parents who are here tonight. Okay, so topics for this evening. Here's our roadmap of where we're going. Terminology and definitions, just so we have a same working knowledge base. Many things are acronyms, as you've probably learned in this field, so I'll take some time to define them. Then we'll talk specifically about compensatory education. As just an overview right now, compensatory education is historically a remedy available to students who were deprived a free, appropriate public education. It's usually a fund of money that could be used for legitimate educational expenses that parents can choose how to use. And it's meant to kind of provide what should have been provided earlier. Then we'll talk about CCS. So CCS is that COVID-19 compensatory services. That's a relatively new development, only since the pandemic, and it's based on guidance from the Pennsylvania Department of Education. And that's meant to say, how do we grapple with the fact that we know there's learning loss because of the pandemic across the board, and we know that our students with disabilities are among the most affected. So CCS is meant to be a process to help remedy and make right the pandemic-related learning losses. We'll discuss the CCS process, what's supposed to happen, and importantly, when, and whether it's a process that's going to be ongoing, as we've learned that, this is not a very quick resolving process. We were out first in the beginning from March to June of 2020, and I think many people and the CCS, process itself kind of envisioned that by fall of 2020, things would be back to normal and we would just be talking about loss during this 3-month period. Well, we've learned that that's absolutely not the case, that, it's an ongoing thing. Virtual and hybrid programming is still very relevant in this time with COVID closures and other issues of quarantines. So then we'll talk about some common CCS issues that I've seen across my practice that you may or may not be able to relate to. And then the big one, what do you do if you disagree? So let's say you were offered or not offered COVID compensatory services. What happens if you feel that that decision was not the right one? And then finally, just a brief word about ESY. Next week, we'll actually have a webinar on ESY extended school year. In and of itself, it's a huge topic, but just because it overlaps a little bit with how many districts and charter schools are providing COVID compensatory services, I think it's worth just a quick word if we get to it at the end. Okay, so here are some of the terms that we'll be using. Comp Ed is kind of the shorthand for that compensatory education, that traditional remedy of a fund that we talked about. CCS is, of course, the abbreviation for the COVID-19 compensatory services, and those are the services that were created in guidance from the Pennsylvania Department of Education in response to the pandemic. Recoupment is a term you'll hear alongside the CCS term and its process. So CCS are meant to be considered after students return to in-person programming, and there's a period of time for recoupment, meaning that the student's IEP and its services will be put back in place and will give the student a chance to kind of catch up, to get back into it, to catch up. And then only after that recoupment, take a look and see, is there really regression at that point? NOREP is short for a Notice of Recommended Educational Placement. That's the document that you get to provide you notice of the action or inaction that the school district or charter school is proposing to take. You should get one with a COVID compensatory services determination. That document is the one that asks you to either approve, not approve, or ask for an informal meeting. And it should be provided you with any decision that the IEP team is making. FAPE is the acronym for the Free Appropriate Public Education. So you may hear me say that throughout the presentation. LEA is Local Education Agency, which in most cases, we're talking about a charter school or a school district. Cyber charter schools too are LEAs, meaning that they are the local education agency who is responsible for providing FAPE to a student with a disability. PCA is short for Personal Care Assistant. This, in some districts, they may use this term, in others, they may use one-to-one. It's usually an adult who is working specifically with a student one-on-one to be there throughout their school day. So not a teacher who's providing services, but a one-to-one who is with the student to help them, usually by providing redirection and support alongside the teacher. And then ESY, Extended School Year. That's for students who qualify, students with IEPs who need more than the traditional 180 days of school, typically because of regression over breaks, may qualify for services over the summer, but regression is not the only way to qualify for ESY, and that's kind of important. Because many school districts are providing COVID compensatory services alongside their ESY program, there's been a lot of confusion as to whether CCS are ESY and vice versa. Okay, so big question here. Do school districts and charter schools have to provide FAPE during the pandemic, or is it excused? Good news is yes. I'm going to say it again. Yes, absolutely. The United States Department of Education and the Pennsylvania Department of Education have expressly recognized that during the pandemic, the right to FAPE has continued. So it is not waived or modified. Students are still entitled to a free, appropriate public education, and it was not suspended at any time. So no matter what approach, whether it's virtual, whether it's hybrid, the IEP team is still responsible to ensuring that the student has FAPE. Now, because of the pandemic, of course, many districts and charter schools have had to adapt because of public health need to keep their students and families safe. That may work, and a student's IEP may be able to be translated into these other approaches and still provide FAPE, but for many learners, it may not, and there may be obstacles to them even receiving FAPE in this. So then the IEP team will either need to adapt and find a way to offer FAPE, or potentially need to consider these COVID compensatory services. So what goes into a FAPE? What are we talking about here as the end goal here? Among other things, it's an individualized program, so it's meant for the individual student based specifically on his or her needs. It's designed to meet those needs, so identify what they are and then provide goals and services, specially designed instruction, so that the student will be able to make progress. The student is, it's supposed to be reasonably calculated so that the student receives meaningful educational benefit, and it prepares them for further education, employment, and independent living. While FAPE was not suspended, also, so too, the timeline for completion of evaluations and reevaluations was not suspended either. So the timelines remain in effect, and they have been in fact. Just for review, in Pennsylvania, the timeline for an evaluation and reevaluation is 60 calendar days from the date that the school district or charter school receives the parent signed permission, absent the summer. So without the summer. So for example, if you returned a permission to evaluate on June 1st and school ended on June 30th, then you'd have your first 30 days in June, then you'd have the summer, which wouldn't count, and then you'd have the next 30 of those 60 calendar days in the beginning of the next school year. While of course, virtual programming has really complicated evaluations in some aspects, in others, there are many ways that they can still go forward, and evaluations can still really gain a lot of relevant data about a student. So for example, though I'm hearing much less of it, I have heard quite a bit of, well, we can't evaluate the student right now because, we're unable to meet with the student or unable to use virtual means. But there are so many measures that can be used that do not require face-to-face testing, even if that would be the best. There can still be observations, there can still be rating scales, there can still be a lot of teacher and parent input and progress monitoring that's been going on. So, really evaluations are still possible in that way. And, typically, I think it would be better to note that, maybe there are non-standardized conditions because of wearing masks or because of social distancing that would not be typical, but still try to get that information, because really at the end of the day, if we don't have sufficient information about a student and his or her needs, then it's very difficult for us to create the right plan for that student. It's kind of like, if the doctor hasn't run all the blood tests, how can they tell you exactly what the course of medication should be? Okay, so here are some issues that are, faced by parents and by schools that, I've seen so many families run into and really complicate the situation. So, there's certainly some students who just are unable to attend to virtual instruction, whether it's because of an intentional difficulty or the combination of several disabilities together, or the need for, adult assistance and prompting. Sometimes that's just not possible for some learners. There are also, frankly, lack of staffing. That's been an issue for many positions. It shouldn't affect a student's right to FAPE, but I think the elephant in the room is that right now certain positions are difficult to staff and that some students have missed hours because of that. Certain students who are medically fragile or have family members who are immunocompromised, whether they can attend in-person instruction safely, whether the family feels that that could be safe, or whether they feel that they must continue with virtual, even if that's not an ideal educational environment for the student. That's been a very difficult situation for many families. The need for prompting or hands-on assistance. If a student had a virtual program for a period of time, but really needs that hands-on assistance, and if that wasn't provided, or if parent had to be there providing it, that was certainly a situation that I think prevented many students from really accessing their program. Another thing is just the inability of staff members to see what the student's doing during virtual. So, if a student is supposed to be making certain writing strokes, but you can't see what the right angle, or the student is getting up and moving away from the screen, or, for many students, just turning the screen off. So we can't really see and engage what exactly they're doing. And then finally, interruptions in schedules and quarantines have been, tremendously difficult for students and families. Not just students who have transition difficulties, but just in general, just, having a period of learning and then losing, a week or so in a quarantine is very detrimental. Okay, so the big question, what if my child wasn't provided FAPE? What can I do? And compensatory education and COVID compensatory services are both potentially applicable in that situation. So we're going to now compare and contrast that compensatory education and the COVID-19 compensatory services. In some situations, it's not always clear which one would be really the remedy for it, or maybe both. So compensatory education traditionally is a bank of hours or a fund of money that parents can use to obtain private services. And the money is provided by the school district or the charter school, meant to make up for a failure to provide a student FAPE. So due to a district's failure to provide it in the past, this fund is established that parents can then, on their own, purchase essentially the private services to make the student whole is the idea. So if a student, should have had reading services for a period of time, and we look at it, we would say, maybe they should have had 1 hour per school day of reading services and they lacked those particular services, then we might be saying, okay, what would it take to create a fund that would be of equivalent value to 1 hour of reading services per day for that period of time. A couple basics here. They're usually held, the fund is held by the district or the charter school, but sometimes they're put in a trust. So sometimes a trustee is involved in managing and accessing the funds, and other times it's just through the district. They're always defined legitimate educational expenses. So this is a fund that is meant to be used only for educational purposes. And so there will always be a definition of what those educational expenses should be, what types would be appropriate. And there's, always pretty much an end date as to when that can be used. It's usually not to supplant the IEP, meaning that you would still have the IEP services from the team, and these services are not meant to come into the school building or supplant the IEP. Rather, they're meant to be done after school, summer, weekends to supplement the program. Compensatory education funds are often the product of negotiation with or without attorneys. They typically will require board approval for the school district or the charter school because money is exchanging hands in a way. The board will have to sign off on a written agreement to provide these funds. They are often the result of a proceeding in a due process hearing. So hearing officers can order compensatory education. They can hear a parent's case and determine that a student's rights were violated and that there was a deprivation. In that case, a hearing officer will typically order a number of hours and may put some conditions on the compensatory education as well. And this is a remedy, it's important to note that existed well before the pandemic. It is not unique to the COVID-19 pandemic. A few things that get considered with compensatory education. So the amount of time and the duration that the student was denied a FAPE. So how long, was it a period of months? Was it a period of one full school year and a half, whatever it may be? And then also, what services makes up that portion of the time? And then it needs to be, reasonably calculated to provide the educational benefits that likely would have accrued from special education services. But in terms of what services, it's really about trying to put the child in the same position he would have occupied, but for the district's violations. That said, it's important to note that there are kind of two different methods of looking at compensatory education. One is this make whole approach, thinking, okay, well, if this violation hadn't occurred, what would it take to put the child in the place that he or she would have been in if that violation hadn't occurred? Versus an hour for hour, which is more of a just kind of a calculation, like I had mentioned before. If the student should have had reading services for 1 hour per school day and they missed it for a full year, we would be looking at potentially 180 hours for 1 hour a day for 180 school days. And then in general, it's meant to be a kind of a restorative remedy. So something that is meant to give the child a chance to catch up and get to where he or she should have been. Contrast that now with COVID-19 compensatory services. So this is a new thing that was recommended in non-binding guidance from the Pennsylvania Department of Education. So non-binding meaning that a court does not have to accept this. This is not the law. This is not a something that the legislation came up with, but rather it is a piece of guidance from the agency, from the Pennsylvania Department of Education. So in order to help school districts and charter schools figure out what to do with all of this learning loss for these impacted learners with disabilities, they gave us this guidance that schools are supposed to consider whether students need COVID-19 compensatory services. So those are services as determined by an IEP team needed to remedy a student's skill and or behavior loss or lack of progress that resulted from an LEA's, that's local education agency, that's school district or charter school, inability to provide a FAPE while using alternative instructional models due to the pandemic. This calculation of CCS is supposed to happen after this recoupment period where the student receives services as set forth in their IEP for a period of time. The idea is to give the student an opportunity to recoup those lost skills and then determine later whether there was enough recoupment or whether there is still a lack. So let's break that down. First thing, it's determined by an IEP team. The really important thing to remember here is that parents are members of IEP teams. So this should not, in my opinion, be any sort of predetermined calculation that someone from the district just calls the parent up and says, okay, well, we're going to give you this many hours. It should instead be a meeting where the parents get to hear the district's perspective, the data that goes into it, and also offer their own perspective, and then that team decides based on both of those viewpoints what the outcome is going to be. It's meant to remedy a student's skill and or behavior loss and or lack of progress. So that could be a lot, in my opinion. Lack of progress to me, would mostly be saying, hey, let's look at the student's goals. But at the same time, I also think that we may have new areas. So that skill and the behavior loss, I think, is really important too, because I think students have been so impacted by virtual education that sometimes when they're returning to in-person, we're seeing new behaviors, we're seeing new loss of skills. And so really, I think we want to think very broadly when we're determining this and not just necessarily at the particular goals. And it's supposed to be due to losses that resulted from the inability to provide FAPE while using alternative instructional models. So alternative instructional models is not defined in this guidance, but we could safely presume it's meant to encompass at least virtual education, but also hybrid education, anything that was a disruption due to COVID, really. So anything that changed the delivery of the students' program from what it was in February 2020 to the different iterations it's had since then. It is not just what happened between March and June 2020, and that's really important. It is definitely not just that, because there have been continued disruptions afterward. And then it's supposed to be considered after the IEP services are put in place for this recoupment period. So the idea is that the student gets back in school and we try to catch them up. As many of you, I'm sure, have learned, the problem is that because it's always changing, we're not really sure when the student gets back to this normal. You know, were they already back last school year, or have they never been back at all since March 2020? Okay, so the process for COVID-19 compensatory services. The way this was originally intended, and actually this guidance was updated as of June 15, 2021. So as it is still apparently intended to be done, it's supposed to be as soon as appropriate, but no later than 2 weeks after resuming normal operations. This is what the LEA should do to engage in this process. I want to highlight that normal operations is not defined, and that it's very unclear what exactly constitutes normal operations or when and if these have actually resumed. So the team is supposed to gather baseline data on the student's current educational level. So that's the level that the student is at when he or she returns to normal operations. Then they're supposed to compare that to where the student was before COVID-19 and determine if there was regression in skills or behavioral patterns or a lack of progress. Now, I would note this made more sense when we were thinking of it in terms of a couple month period from March to June. Then if in September, you looked at where the student was and you looked back to where they were in March and you were trying to get them back to that place, that maybe seemed reasonable. Now we're almost 2 years out from where the student was. So I don't think we want to get back just to where the student was in March of 2020. We should see progress in these last 2 years. So I don't think it's just returning the student to where he or she was in March of 2020, but rather it needs to be focused on whether there has been a lack of progress on what the student's goals have been throughout this time, in my opinion, to really consider what the impact of these alternative educational methods have been. And then, as appropriate, but no later than the third month of school after resuming normal operations, it contemplates that the IEP team is now going to get together. The recoupment period has happened. The student is back. They're going to look at those scores and they're going to say, okay, was recoupment enough? Did the student make enough progress? Or is there continuing evidence of a loss of skills? And if there is, then the team is supposed to determine whether and to what extent the student may need COVID compensatory services to remedy that. Okay, so there are many factors that the state specifically gives us to consider in determining what these CCS services would, whether a student would qualify for CCS. And I want to note that none of them is just a one factor thing, and there's no cutoff, there's no percentage here. It is a very fact intensive, individualized determination. So here are some of the factors that are supposed to be considered. The levels of academic and functional performance. So that would typically be your present levels in the IEP. Those should be gone through, and we should be comparing the student prior to the closures and then after. But we should also be considering observations from teachers and parents. We should also consider the student's ability to access remote learning opportunities or inability, the student's engagement in the learning process, the amount of loss of skills or lack of progress, historical data regarding the student's ability to recoup lost skills or behavior, the services that were provided during the alternative learning models, progress monitoring, and informal or formal assessments. So that's really, it describes to me taking a very thorough, comprehensive look at the student and their progress in multiple different ways, looking at evaluations, looking at input from team members, looking at what the experience of virtual was like, and also looking at those goals. I really wouldn't say that, just looking at goals and saying, whether the student has mastered or not mastered a particular goal is as thorough as what this CCS determination process given to us by the state contemplates. Okay, so now how should the team calculate CCS? First of all, most importantly, it should be on an individualized basis. So this should not be a cookie cutter, one size fits all. You're a itinerant student, so we're going to give you this much. You're a supplemental student, so we're going to give you this much. It should be individualized. It should be based on all of those factors that we talked about whether they qualify, I think would all be relevant here. And so they need to consider the loss of skills and behaviors, and then also how much the student was able to recoup. And then there should be an individualized decision at that point, whether there is any remaining loss and whether the student needs CCS, and then the team should be offering the type and amount of CCS. Now, COVID-19 compensatory services are services that would be provided by the district typically, unless there is some other agreement with the district or the charter school. So they would be offering to provide these services. However, the state tells us that they're not supposed to supplant the current IEP, so they're not supposed to be instead of the IEP, and they also are not supposed to alter the least restrictive environment, so alter the amount of time that students are with non-disabled peers. So due to this kind of rules out the school day in many ways for a variety of practical reasons, and has put most districts and charter schools into the thinking of, okay, we need to look at breaks, we need to look, at summer, we need to look, potentially even at weekends. And that has been one of the reasons that has really pushed many districts toward looking at using or extending their extended school year program as their CCS offering. And then in July, I'm sorry, I said July again, in June 2021, the Department of Education did clarify one thing about transportation. So this part was new as of June. They said that, CCS are not part of FAPE. So they are not included in the IEP. They're not, the same as extended school year, which is part of the IEP. So LEAs are not required to provide transportation, but it can be provided. It can be provided if they agree. And also they did clarify that school districts can use some of the funds that they've received due to the pandemic to fund this transportation. So, excuse me. So essentially, it's not a given, transportation. Okay, so here are some, just summary takeaway points for us. CCS are not considered FAPE. They're not memorialized in the IEP most of the time, though the discussion sometimes is summarized in the present level section. It's usually not built in to the specially designed instruction or to any other place in the IEP. CCS should be decided by an IEP team, and that includes parents. It should not be predetermined. It should be a discussion. Parents can disagree with the proposed type and amount of CCS, which we'll talk a lot about later on in the presentation. There are multiple factors that should be considered. It shouldn't just be, you know, a 1 or 2 score type of analysis. It should really be a more holistic view. And then the Pennsylvania Department of Education has not defined normal operations. So it's a little unclear as to whether we're there yet or we're not, or whether we did resume normal operations, but then maybe at a later period of time, you know, we're no longer in normal operations. So that makes it unclear a bit as to whether this is a one-time process or whether this might be a process that has to be repeated a couple of times. So if you already had a CCS determination that was made, you know, maybe sometime in the 2021 school year, you know, is that something that needed to be revisited and possibly discussed again due to later use of alternative instructional models as well? Okay, so just to get back to our main question here, Compat or CCS, which one? Very unclear. So it can be really difficult to tell, and you know, possibly the answer could be both. So things that I consider when I'm looking at a student's profile. Does the IEP as written provide for all of the student's needs? Or would the student likely not make progress even if provided the services? So the example I usually give is, you know, if a student needed occupational therapy and the IEP does not provide it at all, then it doesn't matter whether it was a, you know, virtual program, a hybrid program. The IEP just didn't have the right services in it. It wasn't a COVID issue. It's just an issue of faith. And that would, to me, really suggest compensatory education versus a student who perhaps, you know, the program could be appropriate, but they can't access it in virtual or hybrid, you know, due to some of those issues we described earlier, you know, whether it's an attention or behavioral issue, something that is impacting the student's ability to attend, or whether it's because the SDI as written just don't translate into virtual offerings. But those would be things that might be more along the lines of CCS. Many times, however, what I find when families come to us for consultations is that it's potentially a little bit of both. There were issues with implementing the program in these alternative instructional models, but the program also may have some issues and some shortcomings too. So between the two of them, I think that it's possible that they could both apply. And in that case, you know, I really think that families would want to have, you know, advice to know that if they're accepting CCS, are, you know, what are the ramifications? You know, could they possibly be entitled to more? Could they possibly be entitled to compensatory education instead, which, you know, could be potentially a larger amount. It could be, you know, something that they could use at their own discretion, has some advantages potentially. Really important for all parents to know, there is a 2-year statute of limitations for claims under the IDEA, the Individuals with Disabilities Education Act. That's what gives us IEPs, and also for claims under Section 504, which is what gives us Section 504 service agreements. They both have a 2-year statute of limitation, meaning that parents need to act within 2 years of when they knew or should have known that the child's rights were violated. So if a violation happens, you have to actually file a complaint and institute litigation at that point within 2 years of that date. If not, those claims may be waived. It can, however, be a very complicated legal analysis. There was some recent case law that has made this a bit complicated, and also just in terms of these CCS decisions, it's very complicated. I mean, I can imagine that school districts will probably argue, you know, parents knew as of spring 2020 that their child wasn't attending in person, And they may try to say that, anything that is more than 2 years from that date is, completely waived at that point. Whereas I would argue that no, it's about, when did you really know? At that point, you probably thought this was just going to be a short-term thing. No one really knew that what the depth and the breadth of these violations were going to be until a later point. The point being that because of this 2-year statute of limitations, it is definitely a complicated legal issue. So if you have any concerns, I'd recommend that you seek help and try to get some professional guidance. Okay, so dispute resolution. If you disagree, what avenues could you possibly take? The first is a due process hearing. So that would be a hearing before a hearing officer who is appointed through the Office of Dispute Resolution. The hearing officer acts essentially as a judge in the case, hears both sides through evidence and testimony, and then makes a decision in the matter. You could also decide to pursue mediation. Mediation is when a mediator will come, kind of work with both sides, see if they can get to a mediation agreement to resolve the dispute. Importantly, the rules for mediation were recently revised, and attorneys are now permitted to attend mediation. But the district or charter schools attorney should never attend if you are not also bringing an attorney. And then finally, procedural safeguards notice. That notice that you get whenever you get a NORAP, that really outlines what this dispute resolution process may look like and important information about your rights. There's also more information at ODR, the Office for Dispute Resolution, at their website. And then there are other offerings that ODR does offer as well. And I see that, though I'm mostly taking questions at the end, I did just see a question about facilitated IEPs. That is an offering that can work. So that would be a facilitator who's going to come to the IEP meeting and try to kind of work it out with the parties. It's not the same as mediation, though it is meant to get at similar aims. One of the big differences from a legal perspective is that when you invoke mediation or due process, you trigger pendency, meaning that the student stays in the last agreed upon placement. So for example, if a school district or charter school were trying to change your child's placement to one that you didn't agree with, and you needed to keep your child in the old placement, you'd be able to do that for the duration of the resolution process only if you get, if you invoke mediation or due process within 10 days of getting that NORAP seeking to change the placement. So that's kind of off topic here, but there's a lot of confusion about how to invoke pendency out there. So whenever I get the venue to be able to share that information, I try to. So facilitated meeting can be a great option, but it would not have the same effect of invoking pendency if you needed it. Okay. So possible remedies at a hearing. If you did choose to go to a due process hearing, what are some of the outcomes? And hearing officers have kind of broad powers to order an equitable outcome. So these are not the only things that could happen. They're just some of the common ones. So a hearing officer could order revisions to a student's program replacement. That could be more hours of something, a different type of reading program. It could tell the IEP team to get back and consider something. It could tell the district that they need to evaluate and then consider the results of the evaluation. The hearing officer could also say that the student is entitled to independent evaluations. So, potentially that might be having a third party, someone who's not employed, by the school district, evaluate the student. Sometimes that's, a neuropsychological evaluation, speech and language evaluation, occupational therapy evaluation, etc. Hearing officers can order compensatory education, so they can order those hours to make the student whole based on past deprivations of FAPE. They can order tuition reimbursement if parents had to privately place the student in a private school to meet the student's needs. So that happens when the district does not offer FAPE and the parents have to go out and pay for tuition somewhere else. They may be entitled to get that reimbursement for the tuition if they were not offered a FAPE. It could result in revisions to disciplinary decisions or placements, or in a student being able to remain in the least restrictive environment. Again, these are just a couple of common things, but it's not exclusive. There are many others. So I want to go back to this list. I won't read it again, but and just kind of review how some of these issues can be resolved or not resolved potentially by CCS or by CompEd. So many of them are important to the CCS discussion, but it gets really complicated in some of these situations. So for example, if you have a medically fragile student or a family member who's immunocompromised, sometimes you'll end up in a situation where the district may kind of view it as, well, you chose the virtual program, so you must have been okay with that versus coming into our program. But the student is still entitled to FAPE unless there's actually been a waiver. And, if that's an option that every other student was able to choose, every other family was able to choose virtual education, then the student should be able to make that same election, and the IEP team will have to work to make that work for the student and to provide a FAPE there. When it comes to a PCA or a one-to-one, those are some really big issues. Some districts tried to provide that virtually and found that was ineffective. Some did send people into the home. Most did not. If a student missed out on time because a PCA was not provided, that might be something that should be considered for CCS, but if the CCS that are offered are not sufficient to really account for the student's loss, it might be worth considering compensatory education at that point. Okay, and then just kind of briefly, I want to go into the difference between CCS and ESY, and then we'll get into questions. So the difference between CCS and ESY again is an entitlement that's built right into the IEP. Students need to be considered whether they require ESY services, extended school year services. And if they do, it's built right in their IEP, and it's a continuation of working on their goals. It's not summer school like credit recovery, because a student didn't get credit or failed a course. It's rather a particularized extension of the program for a student with disabilities. So ESY services would be part of FAPE. They would be free, and transportation would be provided. In general, the decision needs to be made by February 28th, and a NORAP describing the ESY services should be issued by March 31st. A pet peeve of mine is when you get a NORAP that tries to do multiple things at once. It tries to determine the CCS and the ESY entitlement. I really think those should be separate because it's very difficult to answer two things. You might approve one piece and not approve another, and because that makes it very unclear. I would sometimes recommend that families consider asking for that to be broken into different NORAPs. So factors for considering ESY eligibility. Regression is the one you always hear about, but it's not the only one. That's just so important. It's not the only one. All of these factors are built right into the Pennsylvania Code. So whether the student reverts to a lower level of functioning, or recoupment, whether the student has the capacity to recover the skills. But also there's some lesser known ones like interruption of potential mastered skills, or achieving self-sufficiency and independence, or withdrawal from academics, the extent to which successive interruptions in educational programming result in a student's withdrawal from the learning process. So it's not just about whether the student regresses during breaks. And then, of course, severe disabilities will qualify for extended school year services. Okay, so when it comes to ESY, the team should also be considering multiple sources of information, very similar to the CCS determination in some ways, and they should be looking at the progress on goals and progress reports. Reports from the parents are equally important. And then if there are other types of information that the team needs to know, like challenges that are increased during breaks, they may not always be privy to that information. So parents sharing that information is really important. They'll also look at test results, curriculum-based assessments, and other types of assessments. And I see that the ARC is signing back on. So for anyone who's leaving us at this point, thank you so much for spending your time. If you can't tell, I love what I do. I think it's so fascinating. And it's, such an interesting area to work with families on. So just thank you for sharing this. And if you have additional questions, you can always email me.